we just put, it's fine. It's fine, Ron. As long as we say it at the beginning, I think that's fine.
Perfect.
All right, I'm going to step away for 1 second, but I will be back in 2 minutes.
Yep, perfect.
Great.
Your conference will begin momentarily. Please.
God, I hope that volume goes up, Sam. How you been?
All good. It's just been really, really, really busy.
Yeah. Let's see what else. Linda, good morning. You're on mute. Everyone's going to be on mute. We've got like several dozen people showing up.
The problem is there's a green strip going across the Wall Street Blockchain Alliance's sharing computer sound, and I can't expand the box. But if it's is it just sound?
It's just sound that we're sharing.
Okay, never mind then.
You don't need to see my face, Linda. Spare yourself.
Am I the only early bird?
You're the only early bird. Sam's going to be our commentator for this session.
Hi, David.
Hi, how are you?
I am getting better.
Good.
TNT teleconference service. Please.
So I'm going to start muting everyone.
All right, I'm going to go back on mute anyway.
Hi, everybody. Hi, Samson.
Hey, everyone.
How are you, Donna?
Good morning.
Morning to you. Thank you for doing this.
My pleasure.
Great. Hi, David. Hi, Ron. Hi, everybody.
Good morning, everyone.
Your conference will begin momentarily. Please continue to hold.
Ron, is there any way to make it a little louder?
It's on that side, Sam. It's literally not the speaker on this side. So I'm hoping that once they start, it's louder.
Okay. If it doesn't get louder on that side, I'm gonna put it on my.
Okay. Okay, fair enough. It was 76 accepts as of this morning, I believe.
Did you post it this morning, Ron? I wanted to share it, but I didn't find it.
We shared it with members.
Okay.
So we invited all WSBA members.
All right.
Your conference will begin momentarily. Please continue to hold.
Oh, is that the one, Samson, is that when it says your conference will begin momentarily, that's at the courthouse?
Yep.
Mm-hmm.
Yeah. Okay. Got it. Thanks.
That's the 888 number at the courthouse. Before we start, everyone, just good morning. We're going to mute everyone. We've got a lot of people joining. So Sam, thank you so much for this. And if you'll be providing commentary, if anyone has questions for Sam, please put them in the chat. Love you all, but we can't have 76 people chatting at once.
Good morning, everyone. Good to see so many friends. Good to see you, Adam. Looking forward to, this is like the Super Bowl for crypto. So looking forward to listening and commentating. This reminds me of the Rocky movies. I love the Rocky movies. They always have the commentator like, oh, he's taking some real body blows now.
How is he still standing?
Yeah. I was always a Larry Merchant fan, for those who actually watch boxing. And so.
You mean real boxing?
Watching real boxing, and I'm hoping I'm not dating myself too much, but yeah, I think Sam and I will have a few jabs to throw in along the way, and hope everybody enjoys us.
This was a great idea. Whose idea was it?
It was Ms. Donna and Ms. Andrea.
Thanks, guys.
Do courts usually start a little late, Sam?
There'll be a little bit of preliminary stuff. I will say they have 4 hours allotted for this argument. I hope this isn't 4 hours.
No. We have a target cutoff of 11 o'clock. Hopefully that works for everyone. And I know there's a lot of data and information there, Sam, but hopefully we get some good stuff for the first hour.
Who argues on behalf of Coinbase?
Probably Wachtel.
Sam, I don't know if you heard that there's 118.
At the tone, please speak your name.
Ron Quaranta.
No, it was 318, Ron.
318. Thank you, Robert.
At the tone, please speak your name.
Hello?
Ron Quaranta.
Yeah.
I wonder how much legal GDP is being used up today.
It sounds like they have an open line as well, Sam.
Yeah, so currently, folks, for those interested in comments, it sounds like we're hearing about 100 people say hello at the same time.
So for those of you sending chat messages, because we have so many folks here, just FYI, we've muted the group.
You know, Sam, maybe while we're waiting for the recording line, maybe if you're comfortable setting the stage about what we're going to be hearing today and sort of where we are in the process, that might be helpful for some of our non-litigator friends.
You will be disconnected from this conference.
Sure. So I think everybody knows me, but I'm Sam Enzer. Used to be a federal prosecutor in the Southern District of New York, and now I'm the chair of the crypto and fintech practice at Cahill, where, among other things, I work on crypto litigation matters. Full disclosure, I do work for Coinbase. They're one of my clients, but I do not represent them in the matter we're going to hear about today, which is the SEC's enforcement action against Coinbase. The SEC has alleged that Coinbase operated as an unregistered national securities exchange, that they operated as an unregistered broker-dealer of securities, and that they operated as an unregistered clearing agency of securities by facilitating trades in approximately 12 tokens that were traded on the exchange, and through their operation of their wallet and staking services. Coinbase has moved for a judgment on the pleadings to dismiss the case. The SEC has opposed, so the issue is joined, and today is oral argument before United States District Judge Catherine Fela of the Southern District of New York on that motion. Oral argument is, the parties have submitted written briefs, but the judge has questions, and the parties may want to elaborate orally on what they've written in the briefs. And so this will be an opportunity for us to hear how the parties elaborate on their written arguments, the questions the judge has, the comments the judge makes in the oral argument. I would not expect the judge to rule today, but I would expect that we're going to learn some things about how she sees the issues from her questions.
That's very helpful, Sam. Thanks for the color there. For those who don't know me, I'm David Brill. I think I've seen or talked to almost all of you as well. Chair of the Crypto Assets Working Group, and with Ron, helping to facilitate and ask questions and give some commentary along with Sam on the hearing today.
And I should have said thank you, David and Ron, for having me on.
Oh, it's our pleasure, Sam. And for those who don't know, I'm the managing director at FTI Consulting in their blockchain and digital assets group, and work with and talk to a number of the people on this call about different things in crypto and blockchain, helping support growing the ecosystem. So Sam, as we think about this hearing and the pleadings, was there anything that stood out in the pleadings that the SEC filed or Coinbase filed that you think the judge may really hone in on in his questions?
I think
The
central question, and I think maybe take a step back. Let me give you some background on the judge, Catherine Polk-Fela. Very bright. For the crypto sector, we couldn't get a better draw. She used to be the chief of appeals at the U.S. Attorney's Office for the Southern District of New York. So she's very steeped in what does the law require. You know, in the land of litigation, there's sort of two sides of the spectrum. One side of the spectrum is the folks who like to get up in court and try a case to a jury, and they're not so interested in the law. They like the facts. The other side of the spectrum, you've got the appellate wonks, the folks who, you know, facts and pragmatism be damned. What does the law actually require? And here, for this type of issue, which is what is an investment contract? Can you have an investment contract when there is no agreement between an exchange and, you know, traders with no privity to the exchange? Could there really be an investment contract there? I think having somebody who's steeped in what does the law actually require is a good thing. Here's some noise.
Well, it's not saying anything.
I'm not sure what's going on the line.
Sounds like there might be issues on the court side, Sam. I think other people are having problems hearing as well.
Okay.
So Sam, as we kind of think about this, you know, it's fair to say that since the Coinbase is seeking a motion to dismiss, the burden is on them, you know, whether there's no triable issue of fact or that they're just, the SEC is simply wrong on the law, or you may characterize it a little differently, but along those lines. So do you feel like, is this Coinbase really having to make more of their case in this oral argument, or is it more that the SEC has to really give reasons why this relief should be granted to Coinbase? Like, how do you think about who's playing offense and who's playing defense here?
So Coinbase is on the offensive. And it just to be precise, this is a motion for judgment on the pleadings.
Right.
So, you know, you have sort of three phases of a litigation, roughly. One phase is pre-discovery, the pleading phase. Has the complaint, the pleading, alleged facts that if we accept as true are sufficient to set out a claim upon which relief can be granted? If so, then we can proceed into discovery, exchange documents, witnesses, exchange information, and then we try the case on the merits to a jury or a judge if it's a bench trial. And then I guess if there is a loss for Coinbase, you have a remedy phase where there's a fight about what is the appropriate remedy, should there be disgorgement, are there penalties? And then once a final judgment is entered, Coinbase could appeal if needed. And by the way, even if Coinbase lost this case at the district court level, I fully expect they would appeal it to the Intermediate Court of Appeals, the Second Circuit, and ultimately to the Supreme Court. And the Supreme Court, which is a conservative court, would be, I think, a favorable audience.
I apologize for the interruption, Sam. I don't know. We're not getting sound from the court, and I'm not sure if it's two-way sound. We heard other parties dialed in as well.
Can you mute us, Ron?
What's that?
Aren't we on mute?
We are, but we're still getting sound. I'm not sure what's going on the court side.
What I was thinking is that, you know, you're hearing what's going on in the courtroom and probably whoever's, you know,
Yes,
by the mic, but as long as we're on mute, I think we should be fine.
yes, but I think the court had not muted everybody. Like,
Okay.
I'm not hearing anything coming through from the court now.
Do you want to, let me do this. I have my line in. Let me try exiting and re-entering and seeing if we get it.
Okay.
Okay. So while Sam is doing this, we had the good fortune yesterday of doing a webcast on the approval of the ETF filing. And so for those of you who weren't able to join, I highly encourage you to listen to that webcast. Ron is going to repost that to the whole email listserv, and then it was a public webcast, so it'll be available to everybody. I think why I suggest listening to it is it was very interesting to have sort of different approaches to the approving of the ETF. So it wasn't just, I kind of gave a markets overview, but it was really like tax and accounting, what we might see next. And Greg X did a nice job of explaining the mechanics of approval and why, you need a futures ETP before there was, the underlying ETP. So I would
David,
just encourage.
I'm so sorry, but it sounds like the court might be starting.
We're starting.
Okay.
Sam, is it difficult for you to hear?
I can hear it on my phone.
I do have questions for both sides. So I think what I prefer to do is simply ask my questions each side, one side and then the other, not going back and forth between the Howie test, major questions document, things of that nature. And then at the end, if there's something I haven't asked you and you believe it's necessary to my decision, you can please let me know. We'll see how that works. For my friends at the front table, is there a division of labor among the issues? Actually, I just want to make sure I hear that again. So you are Howie, Mr. Tenrero is major questions, and I'm sorry, who else is speaking, sir? Yes, is speaking about staking and the wallet. Okay, thank you so much. All right, and for my friends at the back table, is there a division of labor?
Yes, Your Honor. Ms. I'll be doing my best to handle questions regarding the investment contract matter, and Howie and others. Ms. Eddy is questions doctrine. Mr. Schwartz, best wallet and staking. Mr. Pekin is going to correct all of errors.
Okay, let's hope there are few, although I of course enjoy hearing from him. All right. Mr. Costello, let me then please begin with you, sir. At the last conference we had in this case, one of the early questions I had addressed the degree to which I could take judicial notice of what ends up being the first 33 pages of Coinbase's answer. It is, of course, footnoted. There are sources to it. What is the commission's view as to the degree to which I may take judicial notice of the facts that are contained in that section?
Your Honor, I believe that the bulk of the information that you see in those first 33 pages, and I think 105 by 106, something like that footnote, the information in there is not integral to the pleadings, which is the standard I believe that the court would be following in this instance. On a 12C, the court would be required to accept the allegations in the SEC's complaint as true, and would be required to draw all reasonable inferences from those allegations in the SEC's favor, as well as other documents and materials that are contained in the complaint from which we referenced. All of that the court can consider, but I don't believe that the same is true for the bulk of the material that you see in those first 30 pages. They're just not integral to the SEC's complaint.
There is a substantial portion of Coinbase's briefing and Coinbase's answer, I guess I'll speak to more specifically, that from my perspective is interesting as a matter of optics, but might not actually be determinative. Just to further probe your answer, if I exclude, and Coinbase will tell me why I shouldn't, the references to, for example, their effort to either provide information to the commission or to obtain clarity from the commission. Are you still suggesting that, for example, their discussion?
This is dealing with whether the court can consider on a motion for judgment on the pleadings, and in this ruling, facts alleged by Coinbase in its answer to the SEC complaint. On a motion for judgment on the pleadings, the court can't consider any and all facts. There's only certain facts it can consider. It can consider the well-pled facts of the SEC. It can consider documents incorporated by reference, like an SEC filing. So that's what the parties are talking about.
And when it comes to issues here, be it investment contract related or be they major questions, or as Your Honor mentioned, the staking program, Coinbase has a very different view of the facts. And that's fine. They can have a different view of the facts. And the SEC views the securities transaction component of this one way, and Coinbase views it a different way. And that is just, I think, more. I think I'm trying to say, Your Honor, that I'm just not sure that a 12C is really the right venue to be resolving that factual dispute. And I think Your Honor had actually may have hinted at this during the pre-motion conference, where just wondering about whether the 12C is the right place to be addressing this.
Well, I did, and that's why I'm asking the question again, sir, because I now have a more complete record. I guess the issue is, let's imagine that the commission has described staking in a manner that runs contrary to everyone else's description of it. The DeFi people, for example, have what I think is a really fine amicus brief explaining to me what the wallet really is and what staking really is. And that actually, in some respects, makes more sense to me than the commission's description of it in the complaint. You're suggesting to me that that's a factual dispute I simply can't resolve. Even if, for example, the commission's description of staking is demonstrably wrong. Yes?
If there is a factual dispute, Your Honor, I would say that the court would not be able to resolve that. But if you look at the two different versions, and there are a number of different points that the amicus parties raised, but if the court is drawing reasonable inferences from the allegation, even though the two different versions of that from two different perspectives may differ, the court would be required to draw those inferences in the SEC's favor at this point, given the nature of the 12C.
Well, related to this question, there is a question of the degree to which I can take judicial notice of the factual statements that are contained in the amicus brief. I'm thinking off the top of my head of the historical presentation given by what I'll call the securities law scholars. I think that's how they refer to themselves. And the background material, sort of the crypto for dummies that is presented in the DeFi Education Fund brief. Are you suggesting that I can consider those facts except to the extent that they are disputed or somehow controverted by what the commission alleges?
I think the court could read it as background in considering the legal arguments that are raised. But if it comes to presenting a different version of the facts, that's where I would suggest that the court not consider it, at least not at this stage of the process. If we were to be back here later on summary judgment where there were to be a fuller factual record, then things might be different.
I don't recall the commission's briefing anywhere or their pleadings containing a historical analysis of the antecedents of Howey. Are you suggesting that to what degree can I consider this information in the absence of contrary information from the commission?
If the court is
sounds like the judge would like to be able to consider facts that are set forth in amicus briefs and others that she finds clarify issues and where she finds the SEC's allegations to be unsatisfactory, overly simplistic, or even wrong.
It doesn't sound, or at least you haven't presented in your briefing, an opposing narrative to the foundations, the legal foundations of Howey, or how they progressed from state blue sky laws. And so I just want to know, does that mean you don't dispute what they're saying, or you think that it just doesn't fully answer the question?
No, Your Honor. That is, we we are disputing that, and I think that the easiest way to look at this is that if you look at how Howie itself analyzed these cases, the foundational principles that comes out of Howie in this concept of looking at substance of a transaction and disregarding form to focus on the economic reality, that principle of Howie comes from Justice Murphy's review of the Blue Sky case. And we have looked at what the securities law scholars have said about these cases, and I'm just not sure that you see a principle coming out of these cases like they say there is, that in the context of these things, an actual contract is required. It factually, and as the posture of those cases show, they may have involved a contract, but that is different than saying it is a mandate coming from these cases. And I think that's the point that Justice Murphy was trying to get at there, that in discerning what the concept of an investment contract is, the focus is on the economic reality, where you are to take the substance to disregard the form. That is the way they extrapolated the principle from those cases. And I'm just not sure that the court needs to really get into the detail of those cases to see how the Supreme Court itself interprets.
Changing topics, sir. As I understand the commission's complaint, there seems to be 4 Coinbase services that are being challenged: the digital asset spot exchange, the prime service for institutional customers, the Coins wallet, and the facilitation of staking. Are those the services, the products that are being challenged in the complaint? Am I missing something is what I'm saying, sir?
No, Your Honor. Your Honor is not missing anything.
Okay, Mr. Chenrero agrees with you. I'm sorry, he's providing silent commentary to everything. Thank you. And I'm assuming, sir, not to give anything away because I've decided nothing, but I'm assuming that it isn't a binary decision with respect to all 4. I could find, for example, that there's something of concern, at least for going to discovery, with respect to the exchange, but not with respect to the wallet. Correct? I consider each of those individually, although there are some arguments that are common to all.
That's correct.
There are references in the commission's briefing, and there's I think a footnote somewhere that speaks about the asset hub. And at that moment, it seems that the commission is also talking about primary offerings in the securities. But I did not understand that to be the meat of the complaint. To what extent are you asking me to look at primary transactions as distinguished from transactions in the secondary market, which is what I understand the exchange and the prime services really pertain to?
As we understand the asset feature, Your Honor, we understand that that issuers are able to sell their crypto tokens directly, as Your Honor observed. Coinbase, just judging by the answer that they've interposed, seems to take a different issue as to what features this asset hub actually entails. And so there seems to be a little dispute between the parties, at least as of this point.
So the judge is asking whether this is a secondary market case or a primary market case, which goes to what I'll call the Lewis-Cohen issue, if Lewis is on, which is to say, if you don't have a primary transaction between an issuer and a buyer, there's a serious question as to whether you can have an investment contract between folks trading in the secondary market and an exchange like Coinbase.
As we talk about the principal charges, the Howie-related charges, I want to be sure I understand what is the conduct about which the commission complains. So can you outline for me, for each of the 4 services provided by Coinbase, precisely what it is that you believe Coinbase is doing as to each that runs afoul of the securities law?
So, Your Honor, I'll be happy to address the primary claim. I think Your Honor's questions about the staking and the wallet service, I'll defer to my colleague on that one to explain to the court in a little bit more detail. But essentially, the primary claim on the securities front here is Coinbase's exchange, its clearing agency, and its broker service, which my colleague will address in a moment. But just looking at the exchange and the clearing agency service, what we contend is that there are securities transactions that are taking place on Coinbase's platform, and Coinbase disputes that, and you know that is what it is. But in our view, the securities transactions are taking place, which would mean that Coinbase is currently operating as an unregistered exchange and an unregistered clearing agency. An exchange in the sense that a marketplace for bringing together orders of buyers and sellers, as the Exchange Act defines what an exchange is, and a clearing agency in the sense of settling transactions, ensuring that the transaction goes from buyer to seller, and that also is defined by statute. And our complaint takes through each of the elements of that, but it's essentially Coinbase intermediation services in that sense that are at issue.
And the answer you've just given me is principally focused on the exchange and the prime services, yes?
Correct.
Okay. In your complaint, you make a point of saying, or you make a point of suggesting that there is some novelty to combining exchange and broker and clearing services. I'd like to understand that a little bit more. I believe that Coinbase disagrees with you and says it's not that big a deal, but you've made mention of the uniqueness of it. I'd like to understand why I should care.
So typically, Your Honor, you do not see those three functions, exchange, clearing agency, and broker, combined under one roof, so to speak. And the reason that you don't see that is because of a number of potential problems that poses. For example, if you look at a properly regulated and licensed exchange, the members on that exchange are the broker dealers. If you have an exchange itself that is also performing a broker function, that presents the potential for a conflict of interest in terms of when broker-dealer orders are placed, the exchange might be tempted to place its own broker-dealer function ahead of the orders of the other brokers. In another sense, it presents another conflict in the sense that the exchange might be prone to using the confidential customer information from these other broker-dealers to its competitive advantage over the brokers.
Right.
And
Neither of these is alleged in the complaint, though, correct?
No, that is not alleged in the complaint, but
Okay.
that is so that the court understands why these functions are normally not combined under one roof.
Fair enough. And I appreciate you. Let me try and sharpen my question then. You've just indicated to me that there are reasons why you'd want to not combine those functions. And I appreciate some of the reasons that you've given, and I'm sure there are others. How does the combination of those functions, as alleged here, impact your claim of violation of the securities laws?
Judge is honing in on the fact that these
Separation.
allegations of conflicts are theoretical.
Not in the courtroom. Thank you. Back on the record. Please continue, sir.
So, Your Honor, the issue here is not that those functions are combined, because there's nothing per se illegal about combining the functions. But the fact is that the commission has never registered an entity that has those combined functions. The issue here is, if
Sorry, could you say that again, please? The commission has or has not registered an entity that combines those functions.
so the commission has never registered an entity that has a combined exchange and clearing agency function. It has also never registered an agency that has an exchange broker dealer combination function. But again, there is not anything per se illegal about it. But that is not really the gist of what our claim is here. Our claim is not that they've combined these functions. Our claim is that there are securities transactions taking place on Coinbase's platform. And because there are, Coinbase, in acting as an unregistered exchange, has violated the securities laws, and Coinbase, acting as a clearing agent, has violated the securities laws as well.
Is the logical extension of your argument the argument that the 12 or 13 issuers, depending on whether you count Nexo, N-E-X-O, that they're all violating the securities laws as well, because they're issuing securities that are not registered? Do I understand that? I mean, I understand they're not in the complaint before me, but I'm assuming if what you're arguing is that Coinbase is somehow, by providing its intermediation services, violating the securities laws, that the actual token issuers are themselves violating the securities laws. Is that correct?
Well, not exactly, Your Honor.
Okay.
Because if we look at the platform itself, you were talking about, and Your Honor observed earlier that the bulk of our complaint is directed towards secondary market trading. And so if you look at the secondary market resale of a token, the seller of that digital token is not the issuer at that point. It is a private party who is actually the offeror or seller.
Yeah.
Every sale of a security has to be either registered or exempt. But what you are going to see here is that the bulk, that 9 out of 10 sales in this context are not going to trigger the registration requirement between, a private seller and a private buyer, because Section 4 of the Securities Act provides exemptions from registration. And one of the most common exemptions is what we call the 4A1 exemption, which exempts all offers or sales other than by an issuer, an underwriter, or a dealer. So these private party resales taking place, that is not going to trigger a violation of the laws of registration.
Well, what about the initial offering of the token? When the issuers decided to issue these tokens, a SOL or SOL, for example, do you believe they were issuing securities?
If yes, Your Honor, yes, we were, and if those transactions were not registered, then yes, or exempt.
I'll ask the question, just to make sure I understand this better. I appreciate that earlier I asked you to whether we were focusing on primary or secondary transactions, and I appreciate your answer on that. You're saying that as to these 12 or 13 tokens, when they were initially issued, these tokens were themselves security.
Yes, Your Honor.
Okay. I understand the argument. I appreciate that.
So now the SEC is saying that a token itself is a security, not just the transaction, the token itself.
And the foundational basis for that was a couple of paragraphs in the complaint, or what was the foundational basis for that comment by the commission for each of the 12 tokens, to your recollection?
Yeah, they're basing it on the complaint walks through allegations that the 12 tokens and the Nexo on the wallet were offered as securities, but the SEC has been very inconsistent on whether the token is an embodiment of an investment contract or whether an investment contract is a transaction conveying an underlying token. And if Louis Cohen was on, his mind would be exploding right now.
All right, well, we'll keep listening. I'll have more follow-up questions for you.
Is it the actions of the issuers themselves, the actions of individuals in the orbit of the issuers, or the actions of Coinbase? What am I focusing on?
The focus is going to be on the actions of the issuer, and the developer and the project team together. So what you would call the issuer, just for, if you want to lump them all together as one category. And that is the focus, because the issuer is in charge of maintaining and expanding the network that surrounds this digital token. And I think it's important for the court to understand that the practical application of this, because at the end of the day, these 12 or 13 tokens, they are just computer code, okay? Those tokens are linked.
So smiling, sir, because that's kind of what your friends at the back table are saying, and they're wondering why we're here.
And-
So okay, yes.
And I promise, Your Honor, I will get you there. So it is just computer code, and the computer code is linked on a blockchain, because it's a bunch of letters and numbers that live on that blockchain. But the key here is that these letters and numbers from this code go with that blockchain and its surrounding network or ecosystem. You'll see sometimes the case here. And it's that network or ecosystem that is what drives the value of the token, because the token as code is linked to that ecosystem. It is tied to it. It cannot be.
This sounds like their new pitch on Common Enterprise.
Or ecosystem increases, so does the value of the token. And the issuers and the project team, they drive the value of the ecosystem. So your token being part of this ecosystem is going up or down in value based entirely on what these issuers and project team members are doing and continuing to do. So it is their conduct that would be relevant for the Howey analysis. The way Coinbase fits into this is, aside from facilitating, or I should say intermediating the transaction by serving as the exchange for this, Coinbase is also rebroadcasting all of this by linking to all of the material of the issuer and the project team right there on the platform. When a customer opens an account on Coinbase and wants to look at different tokens to purchase and sees one of these 13 in particular,
The SEC is basically saying Coinbase, even though it's a secondary exchange, could be liable almost like an issuer, almost like an aider and abettor, because it links the project materials for token projects, republishes, broadcasts them.
Include that information. You refer to it as broadcasting, they refer to it as simply the provision of historical information. Had they not done that, would you still believe these intermediation services to bring them within the securities laws, and if so, on what basis?
Yes. The answer is yes. And the basis is because regardless of whether or not Coinbase is rebroadcasting it, that doesn't change the calculus of what these issuers and these ecosystems are. All we're saying is that Coinbase rebroadcasts and amplifies it right there on the platform, that even if they didn't, that wouldn't change the analysis.
Okay, and so therefore the fact that it's simply their placement of these assets on their platform, by dint of the fact that, in your view, the assets themselves are securities. The placement of these securities on their platform, either the spot or the prime, that's enough. I mean, it's gravy as far as you're concerned that they also provide information. And I suppose you say it's even more interesting that there are efforts made to improve or to enhance or to develop their own customer base by having them purchase these assets. But if we're looking at that irreducible minimum of conduct that brings them, you believe, within the ambit of the securities laws, it's the placement on their platform of tokens that you believe to be securities.
Yes, Your Honor, but let me just clarify though.
Please.
The token itself is not the security.
I understand that, right, and that's what Mr. Hinman or someone else who said that. Someone from your shop who's no longer
Now he's
there.
changing his position.
Token alone, not a security. So tell me what makes the security.
So this goes to what I said before about
The
what
ecosystem?
about what it is that someone is buying when they purchase these particular tokens like this, like these 13 examples. When they buy this token, they are investing into the network behind it. One cannot be separated from the other. One is the other effectively. And when they are investing in this, when the value of the network increases, so does the value of the token. That is the way the judge.
So now he's saying it's not the token that's the security. It's sort of the scheme of what the token is promising to give you from earnings from this ecosystem.
And when it comes to Coinbase's conduct, the fact is that because they meet the definition of exchange, and I don't think that they are debating in this case that they otherwise meet the definition of an exchange, and they meet the definition of a clearing agency based on the type of services and functions that they do. I think the dispute here is that they are a securities exchange and a securities clearing agency, because those statutory provisions would only be triggered if there are securities transactions taking place. That, I think, is the dispute between the parties here. But Coinbase's conduct would be if purchases and sales of these tokens, these transactions, these investments into these networks, if the court finds these securities transactions, then by definition, Coinbase is operating as an unregistered exchange.
I suspect that I might have broader questions on this issue in a little while for you, but I am interested in the first instance about your argument to me just now that the token alongside securities is that the person buying the token is buying into a system. You referred to it earlier as a system. How do I know, or how have you made the determination that a particular token brings, the purchase of a particular token, brings with it entree into a system as distinguished from just having an asset that is not security? I'm trying to figure out what about these particular tokens allows you to make the argument that their purchase is not just the purchase of an asset, but the purchase into a system that implicates the security clause.
Sure, Your Honor. I think the easiest answer to that question is that transactions in these particular 13 tokens satisfy the Howey. That's what makes them secure.
That's a little bit circular to me, sir, so we'll try that again. You're saying to me that if I were to go on Coinbase right now, if I were to set up an account, that I could get any number of assets that in commission destination are not security, correct?
I just want to clarify.
Please.
What we've done in this case is we have pointed out 15 examples of digital tokens where we believe investment contract securities are taking place. We have not looked at all of the tokens that are trading on Coinbase's platform, but as I think we could mention at the pre-motion conference, it would be sufficient for the court to find that this one token is a security transaction. We have pointed out 13 where we have, the commission has made the determination that it believes that these transactions, these 13 tokens are security transactions.
I did understand that, and I did not think that by citing these 12 or 13, you were excluding all of the others. What I'm trying to figure out is what is it about the issuance of these tokens? What is it about these tokens that brings them within Howey? And for you to say, well, they satisfy Howey is not a helpful answer to me. For example, there's a fair amount of description in your complaint about what the issuers were intending to do, what statements they've made, what it is about that, whether, for example, tokens are promoted towards either advancing the blockchain or the goals of the blockchain or the blockchain. So that's what I'm trying to figure out. What you're acknowledging, I think, the theoretical possibility that there is stuff on Coinbase, there are assets that are not security. I understand that you've identified these 13 are. What is it about them? And please don't say Howey. What is it about them that you believe makes them security?
Understood, Brenner, and I apologize for
I wasn't understanding the present, but I hope you do.
So I think it would be helpful if we looked at one or two tokens in particular, so we can try to illustrate the point about what we think is making these investments. Because at the end of the day, that's what this is. It's an investment, and essentially the investment depends entirely on the efforts of other people bring value. So if we look at the Chili token, for example, that's the CAC token. That's a sports and entertainment platform. And if you look at how we track the development, you see in a lot of these instances, these token issuance come about when blockchain and network responses. And to do that, these issuers and projects need startup capital. They will sell an amount of tokens to institutional type investors to get the development for the launch of the blockchain. That can be done, and this is not just Chile, this is for all of them. It can be done in the combination of direct placement, initial exchange offering, staff exchange, simple agreements for future tokens where the institutional investor will get the right to a certain amount of tokens after launch. Oh, I'm sorry, my speaking tab. I apologize. And so they set stuff and then with that capital, they then launch the blockchain, they launch the network, and then they continue to expand and add value. So how does that play out in real practice? If you look at Chile, so the Chile, the original white paper and its website feature biography of the founders and their project team, highlighting their past managerial and entrepreneurial background. They then explain how they allocated certain percentages in those initial formations that I was talking about earlier. The Chile issuer had allocated certain percentages of those of the Chile tokens to the founders and the project team to show essentially that these individuals, these founders, these developers have ongoing vested interest in this enterprise at the end of the day. They own tokens as well. And it's to their advantage to do whatever they can to improve upon and expand this value, because when they do that, they benefit too. Now, in 2018, 3 years before Chile was listed on Coinbase's platform for trading, Chile released another white paper stating that they are no longer looking to fundraise at this point. They are now looking to focus on leveraging resources to realize what they call their vision for the ecosystem. Then the team has also stated publicly that as they are able to grow the platform and partner with more of these digital sports teams, because this is a sports and entertainment platform, as they're able to partner with more of these teams, the value, and this is where this comes into play, the value of the token will increase. In fact, in one tweet that they sent out, it demand for CHD exploded, going to bring a lot of value. Then they also make efforts to drive secondary market trading by burning, that's a term for creating scarcity in tokens to make them more valuable. So if you look at that as an example, and the various tokens, they all follow essentially the same initial track of that developmental capital that starts it out, and then it expands beyond that. But this is just an example to show you that this is the way that these issuers and these developers are looking at the tokens and the networks, the ecosystem themselves. They are looking at it as value, and then they are broadcasting this information publicly so that demand is going to increase. And that is the way that we have characterized the allegations in this complaint, because at the end of the day, when it comes to applying Howey, it is an objective test. It's principle-based. It looks at all the facts and circumstances. And we view transactions in these particular tokens as presenting as value propositions. As Judge Rakoff noted, when you purchase this token, you invest in that platform.
And do you mean that at both the developmental stage and the expansion stage, or to you, did those stages, it's one set of tokens at one particular stage, not security, and later set with security? By the way you're describing CHC, it would seem that they were always thinking about how to enhance the value of the CHD token, and therefore both the initial, the developmental offering and the advance and expand offering are both, the tokens that result in there are both securities in your conception of things, which I understand, but folks at the back table disagree with. Is that what you're saying?
Yes, Your Honor. We're saying that it doesn't make a difference whether you have it initially or whether you get it secondarily. And this actually highlights, I think, one of the major disputes between the parties, because the question becomes, if you have an investment contract that can be created when you buy one of these tokens from the issuer, that Coinbase seems to think that you can't then trade that in the secondary market. And this is where both sides part company a little bit. But we think that if the court looks at this again for what these items are, this is a digital token. It is computer code that links to a blockchain. Whether Your Honor is the first person to buy this particular token from this particular computer code, or whether Your Honor then sells it to me and then I sell it to Mr. Tenbrero, it is the same computer code, no matter which one of us has it. It's still the same value proposition.
And so this is where you're disagreeing with Judge Torres in the Ripple case.
Correct, Your Honor. And the reason that we respectfully disagree with Judge Torres is because when you have those programmatic, those are the retail purchasers, when they are buying XRP, they're buying the same XRP token that the institutional buyers are buying. It doesn't matter whether they buy that from Ripple or from the secondary seller. It doesn't matter. It's the same token in the same ecosystem. There's no need to create two different categories of purchasers in that sense.
So the SEC is now taking a position that definitely contradicts what Bill Hinman said in 2018 in his guidance explaining that Ethereum might have been a security initially, but it was no longer a security. They seem to be saying that if the token ties into an ecosystem that has a value proposition, it is a security for all time. Primary transactions, secondary transactions.
So no appreciation. I'm just trying to, I would have thought that everybody buying a token on Coinbase hopes one day that token appreciates value. But perhaps you've seen tokens that where there was no ecosystem. And if so, if it's possible, could you give me an example of one of those where you looked at it and said, this does not qualify?
I believe that the commission has taken the position that the Bitcoin token is not a security. I think that is, I believe that you can purchase Bitcoin on Coinbase platform.
Is that because it's effectively currency? It's a replacement for fiat currency or something else?
I think that the way to look at that is, again, to come back to your question about the ecosystem, there's no ecosystem behind it. And I think that's the easiest way to look at it. Is the way we view these 13 particular tokens is that you're buying the token and the totality of the inducement. If nobody is inducing anything, then you can't be buying that in a sense. And I think that you'll see in instances like Bitcoin, it lacks that centralized function. Now, with respect to the others, as I said, I don't know that we've analyzed all of the tokens on there. I think we've looked at just these particular 13. Now, it's possible, even with these 13, I don't know if I'm sensing Your Honor's next question or not, but
I doubt it.
When people purchase these 13 tokens, is it possible that some people are buying these particular 13 for utility to use instead of to invest? That is possible, but that's not the way to look at it.
Well, I guess it's possible. I thought your argument would be, which is why it wasn't my next question, was that you've alleged that at least someone out there is buying for an appreciation in value. And I have to accept that at this stage. So the fact that there might be someone who just likes the name or thinks that there's something about the issuer that's cool for them, that I guess that there are people who are not. I'm imagining that more out there. There's someone with more money than brains who's buying to buy, but that's not what you're alleging in the complaint. And I'm accepting that, which is why I did that. Let me please do this. I'm going to give you a break. I have many more questions to ask, but I think I'm going to turn to Mr. Margita for a moment because I want to have sort of an intermission to talk talk about the staking of the wallet program. Sir, again, I found very interesting the DeFi education organization, Amicus, in this regard. Are they wrong in their description of what the wallet is? Are they wrong in their description of what staking is? Or if you'd like me to ask the question differently, can I accept their factual statements about how these things operate?
Well, Your Honor, I can answer it ways. One, I think they are wrong, but I think the more relevant point, what my colleague, Mr. Costello, referred to earlier, which is, I think Coinbase and DeFi Education Fund get it wrong, but you don't need to consider it at this stage of the litigation, because what you're talking about is Congress signed broker broadly in the Exchange Act, but we have this judicial test. Both parties agree that. I'm not going to go over it, but you're talking about the application of a 9-factor test where the parties have factual disputes about the extent to which Coinbase acts as a broker through its wallet application. So I think what the DeFi Education Fund and Coinbase are doing is minimizing the function and the substance of what wallet is and does, by emphasizing that it provides, that it's run through software, that it provides technical interface. But at its core, what wallet does, Coinbase, acting as a broker, actively solicits investors for the wallet program. The investors download the app, and the app, even though it only takes a couple seconds, what wallet does is significant. So Coinbase, and it talks about going to a store, you pull cash out of your wallet, just like that. That's wrong. You or I or any retail investor cannot, like going into a 7-Eleven to buy a big gulp, you can do that. You don't need a wallet to do it. You can take $20, $3 and buy a big gulp. To access and engage in the securities transactions on wallet, Coinbase is essential. I don't have a relationship with DEXs out in the crypto universe. I can't pick up a phone and make my own connection with them. Coinbase provides that for its investors. The swap feature that Coinbase markets as part of its wallet feature is instructive. What the swap feature does is, I'm a wallet user. I log on to the app. I want to trade one crypto asset for another. Coinbase, through wallet application, will access liquidity in the DEX market. It has relationships and establishes connections with dozens of DEXs. It will go out and find a DEX that will satisfy the app at the quantity I want to find that liquidity. It will compare prices across the DEX that satisfy the liquidity request. It will do all of this in seconds. It will then present, and this isn't pleaded, but we define swap in the complaint, Your Honor, and at page 27 our opposition, we cite Coinbase's website, which defines swap for the trade as using the protocol within the EX aggregator and the OX protocol to go out and find, to compare prices for that liquidity and find the best price, present it as a proposal to the user to either accept or not. That is not just a technical interface. That is providing brokerage functions, soliciting investors, routing orders, providing advice in the form of a proposed swap. That is essentially, it actually goes farther than what Vanguard or E-Trade would do. Nobody claims that Vanguard or E-Trade isn't an online brokerage because they provide automated tools for users to effect and participate in securities transactions. So I think Coinbase and the DeFi Education Fund, they are wrong in the sense that they're minimizing the function and effect and substance while waving around the fact that it's technology. I think that's a red herring, Your Honor.
Is it only a red herring in your estimation that Coinbase hasn't taken a fee for the wallet service since April 2023? Do you believe that if we were just to think about the wallet function today, if the fact that Coinbase is not today charging anything for it, make it any less or implicate any less?
As you all know, the most important factor in whether someone is a broker dealer is charging transaction-based comp. So no fee could be very significant.
When they were charging a fee for wallets, it was easier for you to say that there's somehow some violation because not only are they performing these services that you believe transcend a technical interface, but they're charging something for it. Right now, today, they're not charging something for it. Is it still violative or does it still implicate the securities laws? And if so, what specific part of wallet implicates securities laws?
Okay, Your Honor. It is, putting aside the transaction-based compensation, it is still a violation. Gel Direct, Hansen, and other cases tell us there are multiple factors, of which transaction-based compensation is one, but not a mandatory or required one. We have alleged several of the factors in our complaint, including active solicitation of investors, the routing of orders, and the giving of advice, the reasons that I identified in my prior.
All right, thank you. One moment, please.
Sounds like we're in some sort of break.
Let's then turn to staking.
Okay, staking.
You or one of your colleagues at our last oral argument expressed surprise that the commission, that Coinbase was moving to dismiss the staking claim. To whoever the oralist was, their view was that actually staking was the strongest of or a strong claim by the commission, who might have prioritized. Maybe. I found staking to be the least traditional investment like of the functions that you were complaining about here. So I'd like to understand what it is about that. What is it that Coinbase does in the staking context that brings them within the ambit of the securities laws? For instance, the validation protocol that is inherent in staking, that's not like normal investing. I don't think of it as such. And I thought your argument was that it was the aggregation or the pooling of tokens in order to perhaps make a particular group of stakers more interesting to the folks who are using them to validate the transactions. That's what Coinbase did. But perhaps I'm wrong. What is it in the staking context that Coinbase is doing that brings them within the ambit of the securities law?
Okay, Your Honor. Yes, I understand what you're saying about validation services. I think what Coinbase is doing is taking an established technology and building an enterprise on top of it. I think Edwards and Rivera are examples of that, where payphones exist, and ETF, the promoter in Edwards, says, we're going to create an investment program based on that. And we're going to use our technical expertise. We're going to install the payphones, maintain them, repair them, collect the coins, and distribute investment returns. That's essentially what's happening here. Investors are giving up their crypto assets to Coinbase's control. They are pooled, and then Coinbase is using its managerial efforts to manage the enterprise, which is the Coinbase staking program. They provide all the infrastructure, they retain third parties, they operate the validators to ensure greater odds of success so that investors will actually earn the rewards that Coinbase is getting.
You just said they operate the validators. May I understand what you mean by that?
They operate the validators, the nodes of respective blockchain protocols. And so here again, not unlike with Your Honor, Coinbase is saying essentially that because its efforts are technical, they cannot therefore be managerial or entrepreneurial, and the case law does not support that.
Well, I mean, you're both fighting over what is ministerial and what is managerial. So one of the reasons I'm asking you what it is Coinbase is doing is to figure out what it is you're upset about. But the second thing is what the things that you're describing them as doing. I want to know, define all of those as managerial, as distinguished from ministerial. I suspect as well that this is another case where you're going to tell me that irrespective of all the briefing on the issue and the differing conceptions, that differing conception simply means that at this stage of the game, I can't dismiss the claim.
I do want to say that, Your Honor, but I won't, because I think you just made the point.
Well, I did, but I just want to, again, this section of our argument is for me to understand what precisely Coinbase is doing that you're upset about? And particularly as staking and wallet, where there is such a divergence between the parties as to what act Coinbase is doing, what it is you think they're doing.
Yeah, Your Honor, that's a fair question. I just want to bring it back to Howie compels us, and its principal faith compels us to look at the economic reality of whether investors are giving up their capital and pooling that capital with the promoter's effort. That's exactly what's being done here. And Coinbase's arguments, and I understand they disagree with the commission's allegation, they are elevating impermissibly, in our view, form over substance. What Coinbase is offering and what they have marketed is that you can put your assets to work, not to validate transactions or provide some other consumptive use, but to earn returns on your investment. Give up their funds, Coinbase pools them and uses them through their, yes, managerial effort. And the case law does not support Coinbase. I understand Coinbase now is pulling back on everything it marketed that its staking program would do. Staking on your own is complicated and costly, they said. Coinbase will do all of that for you. That is,
they're right. They are right.
Okay. There are economic barriers that prevent certain people from doing exactly what Coinbase is providing. Same thing in Gary Plastic. You know, there's an underlying bank issuing a CD, and Merrill Lynch creates an investment program where it undertakes efforts to promote the program and create a secondary market. And then Edwards and Rivera, which I've mentioned also, provide potentially seemingly ministerial things, but they are managerial efforts in furtherance of the enterprise, requiring no effort from the investor to generate the returns that they market. That is, under Howie, an investment contract. That is the economic reality, as we've alleged, of what's happening here.
Well, I guess I have two follow-ups to that. And the first is whether the parties are in agreement as to the specific services that Coinbase is providing. And then secondly, whether one can fairly denote those services as ministerial or managerial. I guess among these issues, there are claims by Coinbase that the investors never actually lose their assets, that they're always retaining custody. And I think in this regard, to me, it sounded, for example, and I realize this is very low tech, but I have money in a savings account, right? You can use my money in the savings account. You can do something with it. I presume the bank is doing something with it, but I get interest on that. Why isn't is staking akin to interest payments on a bank account? And are you telling me it's not because, for example, I'm never going to lose my bank account, and here one could, in certain highly unlikely but nonetheless identifiable circumstances, lose the asset? Because again, there are two things that they're saying. They're saying the asset holder does not give up its ownership to the asset, and they say there's no real risk of loss. Are you disagreeing with them? Are you suggesting that there's a disagreement that however it works out, I can't decide it at this stage or something?
Well, I'm disagreeing with them, Your Honor, in that giving up legal ownership is not required. SEC v. Edwards tells us that. The investors who purchased the payphones that were essential to the enterprise were promised a refund of their capital. The Coinbase's citation to the user agreement about owners do not give up legal, investors do not give up legal ownership is just irrelevant. And there are risks. Coinbase tries to, and we put this in the brief, Your Honor, so I won't go into it too much, but Coinbase is reading into the investment money prong of Howie requirements that simply do not exist. If there is a risk that is inherent to the enterprise, like a cybersecurity incident or theft or loss of private keys or Coinbase fails, that risk matters. Same thing with flashing is a Coinbase specific risk.
Sure, but hang on. The likelihood of flashing happening is really small. But the fact that it could happen is enough? Is that your argument?
Well, Coinbase admits in its answer that it could happen. It just says it hasn't happened, and they provide a limited indemnity.
Yeah.
The risk exists, and that's enough.
What if they had a full indemnity? Is that no longer an issue then? Have you lost that argument?
No, it's an issue under Edwards because they are guaranteed their money back. Gary Plastic is a good case, Your Honor, because the risk, as the court Second Circuit noted, is you could have the underlying bank, the issuing bank that's the go under. But you could also have Merrill Lynch go under and not do what it's promised to do as part of the enterprise. All those risks matter. And so Coinbase's attempt to identify and distinguish between Coinbase risk versus non-Coinbase risk versus staking risk versus non-staking risk is irrelevant.
Well, you've answered my next question, which is I believe Coinbase suggests that the risk needs to be a staking specific risk because they suggest, for example, that certain things could happen whether you solo stake or stake through their program. Certain things could happen if you're just a customer of Coinbase and not a member of the staking program. And there is a suggestion that there ought to be something more, something staking specific. You're telling me that under Edwards and cases like Edwards, there is no act specific risk of loss that has to take place. In this case, a staking specific risk of loss that has to be identified.
That's right, Your Honor. And I think Gary Plastic respectfully washes away that argument because the risk I identified. The underlying bank could go under, Merrill Lynch could go under, and all of that affects whether investor assets are put at risk as part of the enterprise.
Just moving back a moment, sir, to my first question, which I may have the answers to, but I want to make sure I do. What is the staking conduct that Coinbase does? I want it in gory detail. What is it that they're doing that you believe brings them within the ambit of the securities laws in a specific context of staking?
Okay. With respect to the efforts that they market and that they undertake to further the enterprise?
Yes.
Is that what you're asking? Okay. So Coinbase sets up the infrastructure with each of the 5 blockchain staking protocols. They retain third parties to actually carry out some of the staking, although, as I mentioned earlier, Coinbase operates its own validators as well. It provides for increased server uptime, which is important because Coinbase, as we allege, pools investor assets along with Coinbase's own assets and stakes them at validator nodes. And that increases the odds that Coinbase will be selected to validate transactions on that protocol and thereby increases the odds of success of the enterprise. Once Coinbase is selected or a third party that it retains, the validation needs to occur in a timely manner, and that's where the flashing risk comes into play. Coinbase provides maximum server uptime to allow for greater odds of success. Then, when the returns are paid out, and all the while investor assets are staked at protocol during what's called a bonding period, investor assets are not able to be pulled out. Once upon a time, they were as a result of Coinbase liquidity, but apparently they no longer use those. And then returns, Coinbase pays itself, and then it distributes investor returns on a pro rata basis to investors.
How long does that bonding period last?
I believe it depends on which protocol you're talking about.
But is it a matter of minutes, seconds, days?
I believe days and weeks.
Days and weeks. Okay. Coinbase has argued that rewards that are for stakers are set by the individual blockchain protocols and not by Coinbase. Do you disagree with that? Does it matter to my analysis? I sense you're going to tell me that even if that's true, it doesn't detract from all these other things you've just listed for me. But let me have you actually answer that question.
That's right. And to go back to Gary Plastic, the issuing banks CDs set the rate. It's immaterial. What Coinbase is doing is creating on a larger scale an opportunity to profit off of the staking infrastructure. For some of the reasons I identified earlier, Coinbase's efforts make it more likely that investors will receive returns because of the maximum server uptime and because more assets are able to be pooled and staked at the validator node. That's what's more relevant, my opinion, Your Honor.
One moment, please, sir.
Given the tone and the nature of the questions from the judge, I'll take the over under on the judges not going to grant a motion to dismiss as to the staking allegations.
As you know, Coinbase's argument, the argument that they're making is that an economic arrangement can qualify as an investment contract only if it involves an ongoing business enterprise where management owes some sort of obligation, or I think an enforceable obligation to investors. I think as well, in a later stage of their briefing, they suggest that the investment must implicate a claim on the proceeds of the business rather than on the thing that the business creates. In the alternative, that's what they say, you're going after just asset sales. Now, I appreciate that you're taking a different view, and that's why we have this case. But just again, looking at what the limits of your arguments are you taking the position that the purchasers on through Prime or through the spot exchange of these 12 or 13 tokens would have, if they wanted to, one of the traditional private rights of action under the securities laws? For example, if I bought Sol and decided that I don't want to cast aspersions on them. Let's say I bought something that was not one of your 13, but that is just was just rife with fraud. Like there's some hint of that in Terraform, I suppose. But if I did that, what's my recourse as a purchaser? Are you suggesting that by bringing this action, you are by extension enshrining the idea that crypto asset purchasers of at least of these 12 or 13 can bring 10b5 actions, or I suppose actions under the 33 Act for selling unregistered securities?
I think what we're contending, Your Honor, is that when we're talking about contractual obligations beyond the point of sale, I thought that was Coinbase's original position that they took in their briefing, at least in their initial brief. And then in their reply brief, they appear to have refined that somewhat. They appear to be saying it's now the impression of a contractual undertaking. And I'll address that in a moment. But just on the concept of this contractual obligation, what they're essentially looking at, as Your Honor observed, is the question of enforceability in a way. In other words, being able to compel the issuer, for example, of the Sol token, to compel the issuer to actually do something. You know, if the issuer has said, I'm going to expand this network and add a whole bunch of new DApps and features, and if that's not done, then what would the purchaser be able to do about it? And the question is, whatever the purchaser can do about it has nothing to do with whether a security is present. And this issue surfaced in Joiner, which was a long time ago. And the Supreme Court in Joiner looked at this and said that whether or not a purchaser of the leasehold interest could actually compel the defendant to drill the test well, which was the central feature of what made that an investment contract, that was the inducement. And the fact that the purchaser could not, whether or not the purchaser could compel the defendant to drill the test well, was what the Supreme Court said, a question of state law that we, quote, find unnecessary to determine. Reason being, whether or not it's enforceable has nothing to do with whether a security is present, is the point. And I think that's what Coinbase overlooks with this argument, which I'm not sure if that's why they changed the argument in their reply to talk about an impression of a contractual undertaking. I'm not sure I know exactly what an impression of a contractual undertaking is.
Let me explain them my concern. Let's say I agree with you that certain of these tokens, at least one of these tokens, is in fact a security such that having these things placed on the exchange or transacted through the Prime service would amount to operating an unregistered exchange. My concern is, does that mean that every crypto asset purchaser of those 12 or 13 securities can, if they decide they don't like what's happened, bring some sort of fraud action? I am being selfish about my thoughts here. I don't know that I really want to have that MDL. So I'm trying to figure out what is the, you telling me whether enforceable doesn't mean it's a security. Okay, fine. But I actually care about how you're defining security because I want to understand how, not only how it applies in this case, but what it's going to mean to individual purchasers of these crypto assets going forward. And so you'll understand that one of my concerns in this section of our questioning concerns, what are the limits? Are there limits? Are there some guardrails in the commission's arguments? Because I am concerned, and several of the amici have suggested I should be concerned, that what you're asking for is too broad a definition of what constitutes security. So I'm back to my original question, which is, what does my finding in your favor mean for the purchasers of these 12 or 13 tokens?
Your finding in that sense, Your Honor, would mean that the purchaser of the particular 12 or 13 token has purchased a security as in the form of an investment contract. That would be the conclusion. And in terms of what that means significantly, well, if it is a security, then it is a security. Now, there have to be a whole host of other things extraneous to this case that kind of come into play there as to what to do about it.
Of course, and I'm not suggesting that any or all of the token issuers are engaged in any way in fraudulent activity. But if you find, for example, that these are unregistered securities, I would think that in the first instance, the asset purchasers would have a right of rescission. Am I mistaken about that?
They would under Section 12. They can seek rescission if from correct. Yeah.
Okay. All right. So that's what I'm trying to figure out. I care about how the law develops in the case before me. I care as well about what it means going forward, which is why I'm asking about limiting principles or exceptions or areas where even you agree your argument goes too far. So, okay, so you've conceded that finding in your favor potentially opens up the gates to private action. It's not merely the commission who can bring action. There can be private actions by the holders of the individual token if certain circumstances were to happen, or at least if they were to be alleged. Yes, sir?
Correct.
Okay. Now, one of the amici, the Blockchain Association, faults you for arguing that any asset purchased with an expectation that its value will go up based on the entrepreneurial or managerial efforts of others is an investment contract. Is that what you're arguing?
No, Your Honor.
Okay, right. So a few moments ago, you were saying to me you believed that Coinbase had itself pivoted and had changed from contract to something contract adjacent or contract. Here, that is how your test is being presented to me by someone in the space. What is it that you're actually arguing for? You're saying there doesn't need to be a contract, but there's got to be something. So what is this something that's going to be?
And that's a fair question, Your Honor. I didn't know if the court wanted us to address that position. The problem with that characterization from the amicus party is that that's lacking a common enterprise. Just if you buy an item and you just hope that it goes up, that's a lot different than buying into a common enterprise. And that, I think, is what this case is about in terms of what we would look at here, what qualifies. If you look at the way that Judge Castell and Judge Rakoff framed this issue in terms of what is happening in a retail setting, which would be what this is. If there is an instrument present, and you're going to see in some instances that there are, because here we had the initial set, and that's why I mentioned earlier about kind of the history of each of these assets. They all tend to follow the same model, where you have those original direct placements, you have those original sets of agreements, as you did in Telegram and as you did in Terraform. And then what happens is when the blockchain launches and the network develops and then it expands, you then have people in the retail sense buying into, and that's why I said before, buying into this enterprise. And so the way Judge Rakoff and Judge Castell looked at it is they said that if you take the instrument and you take the full set of expectations and understandings that go with it, that is name is not anything nefarious or pejorative. It's descriptive because it looks at the totality of the inducement. Now, are we saying that a contract never exists? No, we're not. In fact, there are a number of digital token transactions that take place, not just in this case as it did initially, but just as what we're saying is that a contract is not dispositive, that you can have the full set of expectations and understandings that embody the inducement. Now, in terms of that, I did want to point out, though, on Coinbase's changing standard here with the impression of a contractual undertaking, because I think that Judge Castell got to this in Telegram, because Judge Castell had said that when the defendants launched this blockchain and then continued to publicly disseminate their plans, continue expanding and supporting it, they had an implied obligation to continue to do that. I think that's what Coinbase might be getting at here. They might be invoking Judge Castell's standard. And if that's what they're doing, then our complaint satisfies that standard, Your Honor, because you have in these instances an impression of that undertaking. If you look at an impression, it's something that I will think of when I see, hear, or read something. And you look at purchasers on Coinbase's platform, when they see, hear, and read all about these issuers, and they can do that easily because, as we mentioned as we mentioned in the complaint, Coinbase links to that information directly, or the purchaser can read about it on their own. But when they look at all of this information, what do they see, read, and hear at the end of the day? They see, read, and hear that this is an investment opportunity, an opportunity to acquire a token as an investment into this network. And so if you add that up, the totality of the inducements in that sense, that makes this an investment.
Once again, I presume you're going to say, based on our earlier discussion, that in isolating or selecting the 12 or 13 tokens that you have, you specifically looked at tokens for which there is this backstory, this suggestion of both origination and then development, such that any purchaser of such an asset either looked at or had the ability to look at this narrative of growth, development, hopefully an increase in the value of the token. That your argument on that.
Yes.
In Coinbase's briefing, they make the point that the asset that they list, and excuse me, I'm not sure this may be in the answer, it may not be in their briefing, but they talk about the approval process that they have, the digital asset support group, and how that winnows away certain assets that are then not included on the platform. But what they say is that the assets that are listed, I imagine by extension, therefore the 12 or 13 you've identified, involve no continuing promises from the issuer or developer to the token holder, impose no post-sale obligations on the issuer or developer, and involve no profit sharing between the issuer or developer and the holder. First of all, as a factual statement, do you dispute what they said? I'm not sure that I guess my question is, do you agree and say it doesn't matter because what I was just talking about, or do you disagree and say it's a factual issue that I won't be able to consider until the summary session?
No, Your Honor, we're not saying that. We agree that, sure, our complaint doesn't allege that our contract between the purchasers on this platform and the developers of the project. Sure. And we contend that purchasers in these tokens are not getting a share of the ecosystem in the form of a distribution or dividend. Sure. But the point is, those aren't required under Howard. Those are just added ingredients that Coinbase has decided to amend the Howard test. So the reason we don't plead that is because that's not part of the test. And as we talked about with the contract side of it, this question about contractual obligations and how you want to characterize it, that's a question of state law. That has nothing to do with whether a security is. And on this other thing about acquiring a share of the business, getting a dividend or a distribution of some kind, I mean, Justice O'Connor, I thought disposed of this in Edwards a couple of years ago, where she had said that when Howard uses the term profit, it's not limited profit of the scheme in which someone invests. It can also include an appreciation or a gain. In other words, it's the return that someone expects in order to participate in something like this. When you have an investment contract, somebody is giving over their money. They're parting with their capital, their cash to participate in this venture, and they expect a return on that. They expect at the end of the day that they're going to get more money back. And they can do that either by distribution or a dividend, or as Justice O'Connor was getting at, a gain. It's similar to stock in that sense, Your Honor, in the sense that a stock can generate a return in the form of dividends, right? Assuming that the corporation decides to pay dividends. The board might vote not to, but most of the time they do. Or a more popular way to get a return on stock is to sell it at a gain. And that's exactly what's happening with these tokens. People buy these tokens hoping, as we saw before with what the chip issuer was talking about, demand is going to explode. So people want to buy these because they look at what the issuers and the project teams are planning, and they think this is a value proposition. So they can buy this token, this computer code, and then they can wait until the value of the ecosystem increases based on this. They're relying on these inducements. And then when it does, that they can sell it on these platforms to someone else and realize the gain. That's what happens.
But again, looking at either the limit sub or the logical solution of your argument, I am presented with the specter of collectibles being regulated by the securities industry. And I'm not minimizing. I mean, I appreciate some people. I've not thought about being babies in decades, and then it's being presented to me in multiple briefs. That's fine. But last time confronted with a class action about beanie babies, what you were, I think, suggesting to me a moment ago what the limits are. So I want to understand how your standard that you've just articulated to me does not sweep in collectible markets or commodities, which is my bigger issue. So what are, I think you were suggesting that it was the sort of the collective undertaking, but let me understand that, because it is a real fear that I have that your argument is just sweeping too broad.
Sure, Your Honor. And first of all, we are not contending that collectibles were secure. So I'll just get that out of the way.
No one is, okay, to be clear, no one is actually suggesting that you are. We're all just afraid that you have so little limitation on your standard that some really thoughtful attorney is going to bring the Beanie Baby class action. So that's what I'm saying. Recognizing that even now you can swear it right here, that doesn't matter. I care about how I know that your test isn't going to implicate either collectibles or commodities.
So the easiest way to look at this is that when you are buying a collectible, let's say a baseball card or a figurine of some kind, you're just buying the item. You are buying a thing. You are not buying into something, and that I think is the difference. There is no enterprise that is involved in this. You know, if you buy a baseball card, for example, you're not buying into the baseball card player enterprise, right? Because there's and other people are not also buying into an enterprise, because that's what the common enterprise requires. You're just buying an item.
But isn't a baseball card the embodiment of the baseball league, MLB?
Yeah, agreed, Sam.
There is no way for somebody to make a baseball card more valuable. It can't be done. You know, the value of that baseball card is going to depend on customer taste and passage of time and what have you. But there's no way to make that more valuable.
I would have thought, for example, in certain collectibles, I would have thought that akin to the burning that one has in crypto assets, you can have a limited edition figurine that would, or you could do something to limit the distribution of something, and that would increase its value. So,
sure, Your Honor, there is that possibility. possibility, but again, I get back to this concept of this buying into something. You're not buying into an enterprise. In order for something to pass the Howey test, in order for it to be a security transaction, you have to have all three elements. It's not just one in three. So it's not just buying something and expecting it to go up. There has to be this notion of the enterprise. Now, what is the enterprise here? What is distinguishing these 13 tokens from a collectible? The fact is the enterprise. And what is the enterprise? It's the network. It's the ecosystem. You are buying into that ecosystem with your token. The token is the key that gets you into this ecosystem. Without the token, you can't get in. The token would be worthless without the ecosystem. It depends on it. And so when you have this collectible, you're not buying into the collectible, you're not buying into the enterprise because there's nothing around it. Not to mention that there's no commonality for your honor, in the sense that under Howey, you have to have multiple people doing this together who are all going to rise and fall together.
I'm just wondering if there are collectibles for which there is a group of people who are working together to ensure that there is a value. It's almost, you don't want to dilute the brand, as it were. But I suppose that's beyond our discussion today. Just one moment, please. I think I've talked to you or your colleague about the securities law scholars, so I don't think I'll discuss that with you further. I understand your standard of the common enterprise to be one of parting with capital with the expectation of profit, or is that just part of the analysis?
Well, that would be the first prong of Howey and the third prong. The second prong is the common enterprise.
Okay, and I have to have all of them together.
Correct.
When you're discussing the Walls WALS case and the Lauer case, you suggest that because of the marketing of assets to unsophisticated investors, a court might find on those facts that an investment contract could exist without requiring ongoing obligations. I guess I have a slightly broader question than that, which is, to what extent today are you asking me to make a determination about the sophistication or not of crypto asset purchasers? And does it enter the calculus at all for me? Let's step back a moment. To the extent you want to tell me that SEC, charge with prospective investor, is really important, I get that. But what I'm really saying is my analysis of whether these assets are securities or not impacted by the sophistication or not. And could I even make a determination if it were?
I don't know that sophistication really is the issue, Your Honor. The issue is, sure, I mean, that's what our mission is to protect investors through exposure. But in terms of whether or not a securities transaction is present, it doesn't matter the level of sophistication of these people who are buying these tokens, because the Howey test is going to be the same no matter what. In other words, I think that's what I mentioned before, where we part issue respectfully with Judge Torres' view and Ripple. There's no need to create two different categories of people at the end of the day, because whether you're sophisticated or not, you're still buying the same token.
So turning to the issue of the reasonable expectation of profits, this is going to be a little bit repetitive, but it's really more to confirm for myself the questions I had earlier have been asked. When you're speaking about the reasonable expectation of profits from a third party's efforts, the third party here are the issuers and developers of the crypto asset and not Coinbase?
Correct, Your Honor.
Okay.
Yes.
Okay. I'm now going back. When we had our first conference, someone at the front table emphasized in a happy way the fact that this was just a consequence of the strict liability. the 33 Act in certain respects, which may be correct, but also maybe a little troubling for me. And I was trying to figure out what it was that brought Coinbase into your crosshairs. And I suppose the real issue is that what it did was it placed on its platform tokens where the issuers of the token were developing an ecosystem, had some plans for enhancing the value of the token. So you're not suggesting that Coinbase acted with any bad intent or did themselves anything to enhance the values of the token, unless you are. I thought your point is by making them available for trading on spot exchange through Prime. One would argue, somebody at your table would argue, through wallet, that's all they had to do. That is, it's nice that they sought investors. It's nice that they touted or at least provided information about these securities, but simply having them on their platform is enough from your perspective. Yes.
Yes, it is.
Okay, because see, the thing about Terraform and the thing about Ripple, I mean, Terraform, Judge Rakoff is of course brilliant, but the decision in Terraform was not a shock to me when you look at the back, when you look at the way he described what was going on in that case. The difference here is we're not talking about the issuer of the crypto asset. We're talking about an entity that put it on their platform. That to me is a level removed from Terraform. It's a level removed from Judge Castell's case. It's a level removed from Judge Barbadoro's case. And that's the concern I have about how these entities should have known. And you or your colleague saying strict liability doesn't make me feel better about it. How folks should know that they were implicating the securities laws. So I'm just confirming it at a minimum, the conduct was placing on the platform stuff that you now tell me amounts to a security.
Yes, the short answer is yes, Your Honor. We're not alleging any kind of fraudulent, no fraud or anything like that. This is just a strict liability in that sense. But I do want to back up because there's another part to Your Honor's question that concerns about, well, you know, all of a sudden here's the SEC and applying Howey and now contends there are securities transactions. That's not quite the whole story. The SEC has been clear for a very long time that Howey is what determines whether something is trading as an investment contract. And we have been clear about that it doesn't matter in what context it trades, whether it trades in an issuer transaction or secondarily. If you go back to 2017, when we first released the Dow report, we were very clear in that report. We were cautioning secondary trading platforms that if they are intermediating securities transactions, then they have to register. That carries through into 2019, where the SEC staff released additional guidance. This is the information that we allege in our complaint and that Coinbase admits being familiar with in its answers. So we've been clear about that, and not only that, Your Honor, but Coinbase itself, at least according to our complaint, at least purported to do a Howey type analysis on its own when it came to the listing process for these crypto tokens. And they had a rather, what at least purported to be, somewhat comprehensive application. So when an issuer wants to list on there, the application requires the issuer to provide information about its founders, its project team, its allocation of tokens to the founders and project team, its plans, its promotions, its accounts, its plans to encourage scarcity, to their listing application that they, I guess, reviewed after they were done looking at it, is exactly the type of information that appears in our complaint. And we have looked at the very same information that they claim, I guess, to have looked at. We reached one conclusion, and they appear to have reached another conclusion, which I suppose is a long way of saying that given that you can have two parties applying the very same standards, looking at the very same facts, and coming to the same very different conclusions, I think is all the more reason why this motion should be denied, just for that reason alone. But for there to be an argument that neither Coinbase nor the market was on notice of any of this, that's just not true.
I do want to turn to the major questions doctrine in a moment, and then we'll have a break, and then we'll have probably just as much questioning for the folks at the back table. They can rest up for it, but I would just like you to comment on one thing, and I know you have in different ways, but again, it's just to give me the decision. In one of the amicus briefs, the one that O'Melveny did, I think that's Enzer and Horowitz, there's an argument that your standard converts the requirement of reasonable profit expectations from the efforts of others into a free-floating expectation of profit, even if the expectation is not enforceable, reasonably believed to be enforceable, or not reasonably believed to be enforceable, or not tied to the actions of the developer or promoter itself. Do you agree with each of those?
No, Your Honor. I think what that party is doing is just restating Coinbase's arguments, but just in a different way. I think, as we talked about before,
The impression argument?
it's the impression argument, but it's the larger point on contracts. I think what you see in some of these briefs is that this requirement of a contract is not what makes something, is not how an investment contract is formed under the law. How is how it's formed. And whether or not it's enforceable is not a securities law question. That is a state question of some kind. And on this question of, turning this free floating thing into issuers and everything else, well, that's where the inducements come from in this case. They come from the issuers of these tokens. They come from these project teams. And as we saw looking at one of the examples earlier, I think it's pretty clear what impression these issuers are trying to give. And if you look at how the allocation of tokens played out initially, these issuers and project teams allocated the tokens to themselves. I mean, it really doesn't take a leap to figure out why that could be. And so when you look at the impression, to use Coinbase's term, that these issuers are giving, the impression is this is a value proposition. This is an investment option. So we take issue, I think, with some of the characterizations in
Thank you very much for your patience. When I became a judge, before I became a judge, I was quizzed by Senator Schumer. And one of the things he was getting at, although I'm not sure I'm supposed to disclose this here, is that he wanted to be sure that I was not going to be an activist judge. However, he defines that. And I'm not going to name the names of the judges in this and other districts that he was identifying as activist judges. I'll leave that for you all to ruminate about. But the point, the larger point, I recognize that I have a lane that I should be staying in. And there's a lane that you all are in. There's a lane that Congress is in. And I actually have received a brief from a sitting United States senator involved in this space who says to me, don't do this, Bela. I have to give that some deference, don't I? I mean, why is she wrong?
Well, thank you, Your Honor. I think that the reason that we have to be careful there, because I think that the Howey test was specifically enacted with the congressional intent in mind. That's what the Supreme Court said when they said, well, contract is defined investment contract. What were they thinking, right? And so I think she's wrong, respectfully, to Senator Loomis, because one senator's view does not override that Congress's will from 1934. I think that could get us very quickly into. So when I became a law student, I read Justice Scalia's book, and he didn't like legislative history because he said it's become a game, and the senator puts in something in the legislative history that says, "Oh, this means," because he knows that respectfully, Judge Bela is going to look at it.
Yeah,
and
well, he wasn't wrong.
That's right. And so I think I don't think that the major questions doctrine is built with the major questions doctrine is there to make sure everyone stays in their lane. And by permitting one senator to say something about it, well, I just disagree with the SEC. I think that really more than just separation of powers concerns, really structural concerns.
Okay, but she's not just random senator. She's someone who is deeply involved in this space and is herself a co-sponsor of legislation to implement the regulation or to implement a structure that she says is not found in the Howey test and that doesn't cover this specific group or type of assets. Why is she wrong?
And respectfully,
Wait, you guys stop saying respectfully. I always wonder what that means. I always interpret that as some insult, some silencio insult. So don't worry. Well, I'll accept that you're all being respectful of whomever you're maligning in your answer. Let's just go from there.
the press might not. Yeah. So that,
Okay. Okay.
I don't. So to take a step back, certainly one of the factors that the Supreme Court has looked at in major questions doctrine is what congressional action or what Congress has considered. I don't see in these cases the court. Well, there's one case in which Chief Justice Roberts closed secret Pelosi. So it's not. I am certainly not saying that the court completely ignored what Senator Lewis or others are saying. I'm simply saying that it cannot be that a senator or even a group of them have the authority to sort of overrule or repeal what the Congress duly enacted, presented to the president for signature in 1964. That could create all sorts of issues with all sorts of laws where.
But they're not saying they're overruling or repealing it. They're saying that we've had a great run. We've had 90 years for which these securities laws have been able to cover all manner of instruments. Now we've got something different. And these are instruments that I'm not saying they were designed to evade the securities laws, but they're just differently, qualitatively than other instruments. And so the argument is, we're not sure whether they're securities, we're not sure whether they're commodities, we're not sure who should have custody of them. But I'm not sure, I don't know that this is necessarily a repeal as much as it is a filling of the void as to a particular category of instruments.
Well, if we simply don't agree that, right? Yeah. So that sort of does, I think, expose a little bit of the circularity of Coinbase invoking the major questions doctrine here in any event. If it's not a filling void because the Howey test gives you the answer in either direction, and we think the direction is still explained, then you're not filling the void. You're simply applying the Howey test, which again was constructed specifically with the congressional intent in mind. That's so interesting about trying to apply the questions to the Howey test. The court said Congress wanted it to be flexible, and there's a line in Joyner where the court said Congress specifically crafted these statutes to capture the countless ways in which people might think to raise funds for their projects. I'm now giving a more abbreviated version of the Howey test that Mr. Costello did, but the point is that's what Congress has wanted to do. And so applying the Howey test to new types of investment schemes, investment products, is in fact nothing new, to be a little circular. The courts have been applying there's the case where there were cattle livery. Payphones, I don't know if payphones existed in 1933, but let's assume they did. There were Court of Appeals cases about, what were called ad packs on the internet in the 10th Circuit, and there's the SG Limited case in the First Circuit. So courts have been applying the Howey test, that's flexible Howey test to these investment schemes for decades. And that has, by the way, not resulted in people bringing basic lawsuits, but more importantly, courts have been doing that because they thought that in doing so, they were effective for special purposes. And so, that's it.
That was abrupt. There's a dispute, I would say, between Coinbase and some of the amici about the significance of the crypto asset industry when compared with something like the energy industry or student loan debt forgiveness. I don't know that the commission really spoke to that, and if you want to speak to that, please do so now.
Yes, Your Honor. So there's it's important to contextualize the size. The Supreme Court in the cases, so there's a number of major question cases, right? Some of them have used
didn't think there were that many, but go ahead. All right.
Somewhere between 5 and 8, depending on how you count.
5 and 8, yeah, okay. Hardly a number, but go ahead. Yeah, go
And
ahead.
so the court, in the cases where the court looks at the size of economic significance, there's a number of ways in which the court does it. One is cost of compliance, and I think that's the landlord case, the Alabama realtors case. They look at the cost of compliance. In other cases, they look at sort of the expansion of the scope. The utility air case, they say.
Slow down. Thank you.
In the utility air case, they say, you know, in one category, you have 800 permit, now you're going to have 82,000, and you're going to increase the cost of compliance from 62 million to 21 billion. In other cases, the Supreme Court looks at sort of the totality of the American economy, and they'll say, you know, in the eviction case, they'll say 80% of the country might be affected. And in loan case, they say 98% of borrowers might be affected. And we're talking about 500 billion in debt, in student loan debt, versus 1.7 trillion in debt. So I'm giving that as context to my answer, which is no matter which of these sort of versions of the economic significance factor one applies, with all due respect to the crypto industry, it does not meet that version. So there's a number of ways to look at it. So first of all, they're playing a little fast and loose with the number. They say, well, it's 1 trillion, but that's a global number, and I haven't seen that in these 5 or 8 cases, right? From the American economy, they're saying that Bitcoin, you know, 1.1 trillion is Bitcoin, which is kind of issues here, and it's a significant portion of these markets. So already they're giving the wrong number in our estimation. And then they're not comparing it to the right number. The commission regulates the 100+ trillion capital market in the United States. And the size of the global capital market is north of $400 trillion. And so when one looks at that, again, I would say, with respect to the crypto industry, they're a rounding error in that sense, right? 1 trillion is a rounding error when it comes to the global size of the global capital market. And so for this quote unquote new asset to be somehow swept in, and of course that's not what we're doing here, right? But even accepting that premise would not constitute a significant expansion of the commission's jurisdiction over the capital market. So that's the context in which I think we need to look at that 1 trillion number that they offer.
Okay, thank you very much. Just one moment, please. I'll see if I have additional questions for you. So bound up in the major questions doctrine, or sort of adjacent to the major questions doctrine, is this idea of the SEC violating Coinbase's due process rights. Are you the person to speak to that issue, other than to just say, no, we're not? I mean, or is there someone else at your table who wants to just briefly address that issue?
Your Honor, I think Mr. Costello addressed it already in some ways. I'll try to repeat. We are not, and the reason we are not, so it's a fair note argument, that's a due process argument, I think, and we are not violating Coinbase's due process rights, violating fair notice principles. The courts have been clear that if we apply Howey, that's the notice you need. Judge Deary in Brooklyn said it in 2018. If anything else were needed, we issued the Dow report to sort of make clear the commission's position. And what fair notice and due process require is that the party know, the regulated party, particularly in the context of civil regulation, that the party knows the test that's going to be applied, not the outcome.
Okay, thank you very much. Let me do this because I tend not to look at time until my deputy tells me to look at the time. We've been 2 hours at this. It's been very productive. I imagine we're going to have the same discussions with the back table. It'll be somewhere in the 90 to 120 minutes mark. I'm going to take a break of 15 minutes just because folks have been sitting here for 2 hours or more. I want you to have that. If folks had plans to break for lunch, someone, and I mean really the folks at the front 2 tables, I'm sorry, don't care about the rest of you in the gallery, but if folks have plans, I didn't think you did, tell me and I'll see what I can do. But my plan was to go and to finish questions for the folks at the back table and then allow each side very brief summation in the sense of anything they wanted to tell me, but I didn't ask a question about. That's my plan. If you guys have different thoughts, talk to each other and then talk to me in about 15 minutes. I'll see you then. Thanks very much.
So Sam, we'll end the call there.
All right. I think that was pretty interesting. I don't know. What are any questions, Ron, or thoughts?
As a non-lawyer, Sam, I'm kind of struck. Some folks have put it in the chat as well. The kind of circular argument coming from the SEC, and again, as a non-attorney, it seemed like the judge had to repeatedly say, paraphrasing, "That's great, but that's not my question. Let's go back to my question." And I think that's part of, I struggled with understanding where they defined or drew the line in enterprise, which seemed to be flexible, but some lawyer tell me if I'm not understanding that premise fully. It just seemed like
No, I think you're getting it. I think you are totally right that there is there are some very serious logical weaknesses in their argument, especially when it comes to what is an investment contract? Can it extend to the secondary exchange?
Right.
And you heard the judge express concern about extending these rules to a secondary market actor. She literally said, I have concerns about it.
Yeah.
On the other hand, I thought, on staking, on the one hand, she said that she sees the staking arrangement as less like many investments.
Mhm.
But on the other hand, I thought the tone of her questions was less aggressive and skeptical of the SEC's position. I thought the SEC framed it as a fact issue concerning whether the provider of the staking service is providing a managerial service versus a ministerial technical service. And if there's a fact question about it, that is not usually something you would resolve on a motion for judgment on the pleadings. It's something you would want to take discovery and have testimony about to resolve the fact issue.
Right. And Sam, the one other thing that sort of made my head explode, unless I misunderstood it, was the SEC attorney's comment that there's no network behind Bitcoin, or there's no something behind Bitcoin. And I was kind of stunned by either his lack of understanding or kind of trying to parse the perspective on what the Bitcoin blockchain is. And I was very impressed with the judge's understanding of the mechanics of some of these things. Staking, for example, she seemed to get it. But I certainly want, we've got some guests here as well that I know some folks invited, but I'd love to hear other people's perspectives as well. And I'm sorry we can't do all 4+ hours of it. Anyone have thoughts, or anyone will make additions to that? Josh, go ahead. Yeah, you should all be able to unmute unless I screwed something up.
Okay. So one thing, thanks, Ron and Sam. One thing I thought was really interesting was about the part where the judge had said, asked the SEC, would collectibles fall within this? And the SEC said, no, we're not saying collectibles are securities. And the judge actually seemed, at least my recollection is, that she seemed to back up and say, well, could there be some instances where there are? But I just thought that was almost some kind of a win for the industry, or certainly for digital collectibles, that the SEC appeared to be saying, we're not saying that collectibles are securities. Now, he may have been talking about Beanie Babies, right? But I just thought it was an interesting statement. I don't know if anyone else had any thoughts about that.
It's definitely interesting, but I wouldn't take it to the bank, because what the SEC, first of all, you heard them reverse themselves like 15 different times within this argument on the issue of, is a token a security, or is it a scheme, or is it a transaction involving a security? They went around and around and around. But also on collectibles, I think what the SEC would tell you is, yeah, the collectible is not a security. But if you market a digital collectible a certain way, then it's part of a scheme to induce people to invest for the hope and expectation of profit from a common enterprise.
And Sam, one other thing on that, if I could, did I misunderstand the judge's perspective where, paraphrasing again, she almost said, I get that you're not saying collectibles are right now, but let's look forward to a future where, can this be used to call collectibles a security? Like, was I misunderstanding her perspective?
No, I think you got it right. She's saying this is the problem of executive power. Okay. The attorney in the courtroom today says, I don't think that would be reasonable. But if the court adopts their argument and there's a precedent that talks about digital assets on an exchange, and it's read broad enough that it could be applied to collectibles later down the road, there's nothing to stop, you know, the next SEC regime from saying, well, that precedent means we get to regulate collectibles.
Right. Well, Sam, thank you for hosting. I know a lot of us have meetings. If I get enough people asking me to go back on, we're probably available at 1:30. Someone DM me, I'll try to dial back in with the WSBA as well. Josh, Sam, any last comments?
Nothing for me. Thanks so much.
Sam, so grateful for your thought leadership, and everyone on the call as well. Thank you, everyone. We'll leave it there, and we will talk again soon. Thanks. Bye-bye.
Thanks so much.